In Penfield, New York, a suburb of Rochester, New York, a construction site was underway when a U.S. Occupational Safety and Health Administration compliance officer happened along the construction site and, seeing an excavation, conducted an inspection. The only person there at the time was the supervisor for the general contractor. They conducted their inspection together. At the opening conference, the compliance officer asked to meet with the staff for the excavation subcontractor. There, they discussed the excavation, and the compliance officer issued a citation alleging a failure to properly shore or protect the excavation or trench against the possibility of cave-ins. The excavation company contested the citation. We're going to discuss OSHA's theory of the case as well as the employer's defense on this edition, the April 29, 2026 edition of the OSHA 3030. Well, welcome everyone. I'm Manesh Rath. I'm an attorney at the law firm Keller and Heckman in Washington, D.C. For about 31 years, I've been engaged in representing management in the field of occupational safety and health law and other areas of workplace law. And we've been doing the OSHA 3030 for 13 or 14 years. Every single month, we put on a 30-minute program covering a developmental area in the field of occupational safety and health law. I'm very fortunate because today I'm joined by my good friend and colleague, Ben Idzik. Ben, welcome to the show.
Thanks for having me, Manesh. Always a pleasure.
Well, it's my pleasure, and I think we got a great topic. Ben, this goes to the employer's defense that whether or not the condition fit the scope of a standard and whether or not the employer had failed to meet the requirements of a standard, if there's no employee exposure, the employer argued, in this case, Pooler Enterprises, you can't issue a citation. That's not a violative condition. And so we're going to talk about that defense, this employer exposure defense in today's edition of the OSHA 3030. I think it's a really important concept to discuss amongst our OSHA 3030 community. And I think it's a really important one for the judge to have considered in this case. So I think Pooler Enterprises is going to be an extremely helpful case for employers and OSHA law practitioners on both sides, the agency side as well as the employer side, for years to come. Why don't we start by talking about what we're going to talk about?
Yeah, so we'll begin as always with the facts of the case, and then also discuss the events that precipitated the citation.
Right, and then we'll talk about what OSHA's argument was in issuing a citation, as well as Pooler Enterprises' defenses.
And we'll conclude with how the ALJ decided the case, and with the what employers should do section, where we provide some practical takeaways that folks in the 3030 community should come out with this case.
Yeah, I think I've always felt like that's the most critical part of our program. I mentioned, Ben, that we've been doing this for 13, 14 years. All of our prior episodes are housed on our website, khlaw.com/OSHA 3030. And you can also find this as a podcast as well as housed in YouTube. So when you go to our website, khlaw.com/OSHA 3030, you can see all of the prior episodes organized by year. And what you'll find is a video and the slides and audio so that you can just play it along as if you were joining us live. All right, so let's go ahead and get into the facts of the case. I think the first thing to talk about, this is a construction site in Penfield, New York, near Rochester. And what's happening at this particular work site is, at least with respect to Pooler Enterprises, is that there's an excavation activity underway in order to lay the water main for this future building site.
Right. And so, like Manesh, like you mentioned in your intro, the compliance officer entered this work site. I think it was part of a randomized inspection that was conducted in the area.
There's a national emphasis program, as you know, for excavations and trenching. And so anytime a compliance officer sees a construction site where excavation or trenching appears to be present, they can just stop and conduct that inspection.
Right.
In accordance with that national emphasis program or regional emphasis program.
Yeah. So the compliance officer entered the work site and walked around with the site's general contractor. And during that walk around, the compliance officer noticed a excavated trench, which, like you mentioned, housed a main water line that was dug by the defendant in this case, which would be Pooler Enterprises.
Right. And the only person during this walk around, as you said, was a supervisor from the general contractor. And this is important because after the walkthrough, the compliance officer conducts an opening conference, and at the opening conference asks if he can speak with staff from the excavation company, Pooler Enterprises.
Right. It was during the walk around that when the compliance officer noticed that the trench was not provided with any cave-in protections, the compliance officer took photographs, but then, like you said, later addressed it in the opening conference.
That was according to the way the judge described the facts. That opening conference was the first time the compliance officer had an opportunity to meet with folk from Pooler Enterprises. And so the two people he met with from Pooler Enterprises were the site supervisor and the pipe supervisor who's directly supervising that task. And so he met with them. They discussed the excavation. They discussed whether or not there were protections like shoring or benching or trench boxing, and there were not any of those features present. And the compliance officer afterwards issued a citation for failure to provide for cave-in protections.
I think the interesting part is during the opening conference, the compliance officer discussed with the two employees you mentioned, Manesh, which would be Mr. Jackson and Mr. Kinsman, why the trench was open, and they discussed that the pipe in the trench was being tested for water leaks. And that is going to come up later in the argument section, I think, and proves critical as to why this citation was ultimately vacated.
Right. Testing for water leaks is a critical next step after laying down the water pipe. So he issues the citation. He claims later that when he interviewed them, that they had stated that that there was activity that was going to take place involved with that testing that would have involved entry into the excavation. But at the time he interviews them, they don't say anything of the kind. This is important, and we're going to discuss that a little more later. But at the time of the opening conference, the only thing that was discussed was this is a trench. It's greater than 5 feet. There's no shoring. There's no benching. There's no trench boxing. And on that, he concluded that a violation had existed. I think that part of the opening conference is really critical because, and you guys here in the OSHA 3030 community have seen this slide before, but for those of you who are catching us as a podcast, I'll go through it. There are 4 elements that OSHA has to establish when they allege a violation of a specific standard. These are different from under the general duty clause, but they have to be able to show that the scope of the standard applies to the condition that they're alleging a citation for.
Right, and to that end, the standard has to be violated. It has to be
The requirements of the standard need to be violated. That's right. And then the next one is that one or more workers had access to the cited allegedly hazardous condition. In other words, that there was exposure to an employee of an allegedly hazardous condition.
Right. And this is the point that's at issue, particularly in this case. And the fourth element would be that the employer knew or should have known with reasonable diligence that there was a violative condition that existed.
Employer knowledge is always a required element for the agency. Here, as you say, Ben, the folks at Pooler really wanted to focus the judge's attention on one of those 4 elements, that there was no employee exposure to any alleged hazardous condition. OSHA, when they go before the administrative law judge, made the argument that they took measurements, they took photographs, the excavation was greater than 5 feet. Indeed, I think it was like something more, well over 6 feet, 6.5 feet deep, and that there was no shoring, that there was no benching, tapering away, getting wider and wider as you go out, and that there was no trench box. The trench box, to me, for a narrow, deep cut, seems to be the gold standard for worker protection. And the compliance officer said that demonstrates that there was a violation. Those are the elements that I need to show.
Right. And what's critical is that in terms of exposure, the compliance officer testified to the ALJ saying that Jackson and Kinsman told him during this opening conference, presumably, that Kinsman was in the trench prior to the inspection that the compliance officer conducted.
For the purpose of testing water pressure. Right. What Kinsman may have said was we were engaged in testing for leaks. It was maybe in the compliance officer's visualizing how that must be done that he assumed that required entry into the excavation, but indeed that wasn't necessary at all. You can test for leaks without entering the excavation. Pooler's defense was it doesn't matter if the trench was greater than 5 feet and that there was no trench box or shoring, uh, there was no employee who was going to be exposed to the hazard unless you have entry into the excavation or somebody walking right at the edge of the excavation. There's no hazards to any of the employees, and thus there's no violation. That I think is the essence of the Pooler defense. They didn't raise four, five, six defenses. They just said there's really one problem with your case. You haven't shown that there's any employee exposure.
Yeah, and that's because with the elements that we saw before, OSHA has to prove all four. You only need to show that one of them does not apply for the citation not to be valid.
Yeah.
So with what Pooler said, like you were mentioning, Manish, is that um, the employers didn't have to enter the trench at that point to conduct the testing. And I think with both the employees which provided testimony during the proceeding, they explained the normal process of how this testing takes place, and they made it clear that at that juncture, no one had to enter the trench, therefore there wasn't exposure. And I think a critical point that certainly the ALJ stressed in his decision was that the compliance officer admitted that Jackson and Kinsman's statements were not that the statements saying that that they were employees in the trench, that these were not in his field notes. So there wasn't a contemporaneous account to back up with what the CO was testifying at the time.
That's really critical. And I think what may have happened, giving the compliance officer the benefit of the doubt, is that he testified that when he had the opening conference, that Jackson and Kinsman said, well, yeah, we need to enter the excavation in order to test for leaks, when in fact all they said was we need to test for leaks. What Pooler said in their defense is, yeah, we may have said we need to test for leaks, but you don't need to enter the excavation for that. This is really critical because what the agency needs to show in order to show exposure is they need to show either that there was actual exposure or that exposure is reasonably foreseeable based on an operational necessity. So if the compliance officer was able to establish that in order to test for leaks, it was necessary to enter the excavation, then he may have actually made his case for employee exposure, even if he never observed any exposure himself. That was what the administrative law judge said. But if, as Jackson and Kinsman had both testified, you can test for leaks, you can insert the pipe with machinery, and there doesn't need to be any entry into the trench, into the excavation by any worker, then that missing component, in fact, what they've done is establish the opposite, and that there's a missing component, therefore, on employee exposure. They've demonstrated the opposite, that it was not operationally necessary for any employee to ever enter that excavation in its unprotected state. And I think that their testimony was very clear on that. They walked through in their testimony the procedure involved for testing the leak for every step of the excavation, and both of their testimonies matched, in addition to their testimony about how that opening conference went, which was at variance with the compliance officer's recollection. You made a good point, by the way, that his recollection was different from his own field notes.
Mm-hmm. So when we get to the ALJ's decision, we look at the point of law that you mentioned, Manish. In order to show exposure, you have to show either that an employee was actually exposed to danger while the inspection was taking place, or that it was reasonably predictable for the employees to be exposed to the danger that the standard is meant to protect against.
Critical two opportunities for the compliance officer, not just observation of his own, but can show through operational necessity that would have happened, that exposure would have happened.
Yeah.
So let's talk about the administrative law judge's decision.
Yeah. So we see that, like we just mentioned, that exposure is the key here. And there really wasn't any other evidence but the credibility of the witnesses. We have the account of this compliance officer, and we have the accounts of Jackson and Kinsman. So that's what the case went down to. And the ALJ observed the inconsistency of the CO's testimony in terms of that he stated that Jackson and Kinsman told him that Kinsman was in the trench prior to the inspection, and with what Jackson and Kinsman saying that was not the case, they were not needed there. And because of that inconsistency, I think the ALJ really came down on the side of Pooler in this case.
So the credibility of the compliance officer was also, unfortunately, at question, because the first thing he said, and I think he overstated it, was when I met with them at the opening conference, they said they needed to enter the excavation in order to test for leaks. Then when the Pooler Enterprises attorney asked him, "Can we see your field notes?" the compliance officer went through his field notes and said, "Oh, I don't see it in here. I may have overstated that." The judge, I think, very giving them benefit of the doubt, very graciously said, "Well, at the very best, his recollection may not be reliable."
And there's also an interesting side note on the credibility issue in terms of the idea of what is hearsay. We see that for all the OSHA nerds out there, we see that what the CO is saying is he's speaking to a hearsay fact. So he's saying that Jackson and Kinsman told me that this happened. By contrast, what the two Pooler employees are saying is that this is actually what happened. It's their own observation. So I think, to your point, Manish, that also went to the idea of who's more credible.
That's a great catch. That's a very good point, that his testimony is about what they said. And you're right. Their testimony was not only what they said in the opening conference, but what actually happened during the operation. That's a really good catch. Okay, so the administrative law judge on these bases found a deficiency in the four elements and vacated the citation. We should talk about what employers should do in light of the Pooler Enterprises case.
Yeah. I think the first point, and this comes up, I think, frequently with these citation contests, is to ensure to the best of your ability to document the inspection contemporaneously. So whoever the person that is either at the opening conference or walking around during the inspection, that they take the same notes of the same portions that the OSHA inspector stops at, take photos the same photos that the OSHA inspector takes, videos, and so forth. And the point here is to be able to, if the citation ultimately goes before the ALJ, is to be able to back up your version of the events with more than just testimony.
I think that's right. And I think that another thing that employers can do in light of the Pooler Enterprises case is to be prepared to educate the administrative law judge or the compliance officer as to every step of the procedure that the employer is undertaking at the work site, so that there isn't this misunderstanding that we saw in the Pooler Enterprises case. The compliance officer just assumed facts not supplied to him, that if there was a water leak test, that required entry into the excavation. And indeed, that was just sort of filling in the gaps of the picture that was being depicted for him. And I think it's really critical for employers going forward to learn from that and say, we need to prepare as clear a presentation of the procedure as possible, both for the compliance officer as well as the administrative law judge.
And I think another point, I think similar to the one I raised before, is when there's an opportunity to do so, try to get more than one employee to participate in an inspection or in an opening conference. And again, the idea is here to have more than one person backing up with what the version of the events is. I think, as we see here, I don't think it was explicitly stated by the ALJ, but I think it did make a difference that the fact that there was one compliance officer's testimony, but also testimony of Kinsman and Jackson saying the same thing in concert. And I think that definitely helped in terms of the credibility of Pooler's defense.
Yeah, I think that's right. I think that two people not only made for two witnesses, but even in the opening conference, it allowed both of them to supply helpful information to the compliance officer to better educate the compliance officer. And so to the extent that they each were able to contribute varying aspects of their own expertise, that was probably helpful as well. I think the next thing that employers ought to consider in the Pooler Enterprises case is to look for all of the evidence that does exonerate the employer in any of those four elements. And if it goes to employee exposure or the lack of employee exposure, to prepare all of the evidence you can possibly prepare, including this idea of walking through, educating the judge on the operational procedures. Because remember, the compliance officer, according to this administrative law judge, need not prove that he observed or she observed employee exposure. They can establish exposure because if they can establish that it was operationally necessary for an employee to eventually enter the excavation even after the compliance officer had left the site. So it's important to prepare all of that evidence and to make that clear presentation of the evidence.
And I think finally we can say that even though it's difficult sometimes to get folks off the job site, to adjust schedules, to juggle that around, but do your best to present more than one witness if a case goes before an ALJ. Again, we see that the more evidence that an employer is able to provide, it generally is helpful in terms of contesting a citation.
Yeah, I think that's a great point, Ben. And there's always this balance that employers and their counsel try to strike as to a compromise between putting on a sufficiency of evidence and running a defense economically. And so the number of witnesses is obviously going to be something that you have to debate. That you're going to prepare, how many witnesses you're going to prepare, and how many of them you're going to bring to trial. But as a general rule, if multiple witnesses are corroborating a truth, then I think it's important to heavily weigh that in calculating what is the right way to effectively mount a defense. And so I know it's tough, but employers have to consider making sure that if they present a defense like a lack of employee exposure, that they do so not only with sufficiency of evidence, but with an overwhelming case that's just clear cut, even for an administrative law judge that may be doubting the defense initially. Well, those are the kinds of things that we think are critical in this case, the lessons that we can take away that you can walk back to your workplace after this program and make your compliance program just a little bit stronger. The other thing I'd say is when you go into an opening conference, I think the other lesson that Kinsman and Jackson teach us is when you go into an opening conference, a lot of employers try their best to make their winning case right then and there. And I don't think that that is the best opportunity to try and disprove anything that the compliance officer is alleging. At this stage, they may just be considering all of the facts. I think that at an opening conference, it's important to remain truthful, to help the compliance officer be cooperative in helping them understand the facts accurately. But to try and win a case in an opening conference is probably a misplaced ambition, and that ought to be done later once you have successfully participated in an opening and closing conference in a manner that's truthful, succinct, helpful to the compliance officer. I think that that's the best you can hope to achieve in those conferences, and not to try and win a case, straight from a home plate to try and round all of the bases at once.
Mhm. I think we see a similar principle come up with traffic tickets. We don't want to argue with the police officer. If there's a case to be made, you can make it later.
There's always a risk that in arguing with the compliance officer, you just appear argumentative or obstructionist, and that may not be the intention that you had supplied that helpful information with. So lots to consider, and I think Jackson and Kinsman did a good job, and the administrative law judge did an excellent job in analyzing the employer exposure case effectively. Well, that's today's OSHA 3030. We have sister programs that you should know about, the REACH 3030 and the TSCA 3030 on the TSCA 3030 on May 13th at 1 p.m. Eastern, and the REACH 3030 on June 10th at 10 a.m. Eastern. These are great programs. If your organization is responsible for complying with these legal schema, then you should please forward on information about the REACH 3030 and TSCA 3030 to your colleagues within your organization. Once again, as we always do, we ask that when you get an invitation to the next OSHA 3030, that you forward it on to at least 3 other people each time within your organization, safety professionals, in-house counsel, and at other organizations. Your help in spreading the good word has been the lifeblood of the program and will continue to be, hopefully for another 13 or 14 years. So thank you for that, and please keep doing so. Our next program will be on May 20th at 1 p.m. Eastern. We look forward to seeing you then. We thank you for participating in the OSHA 3030. I want to thank Ben Idzik, and on behalf of Ben and myself, thank the staff here at Keller and Heckman who have helped put this program on. We look forward to seeing you on May 20th for another episode of the OSHA 3030, and until then, stay safe.